Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Welcome to Trial Talk, insights from legal expert Michael Joseph. I'm Sam Henniger, and I'm excited to talk to Michael more today because we're going to dive in on medical malpractice. So to get things started, Michael, would you mind recapping for us what medical malpractice even is?
Medical malpractice is basically the failure of a doctor to do what a reasonably competent doctor would do, whether it be they don't recognize a condition that the patient has, which is evident, or they fail to properly treat a condition, or they do take actions which a reasonably prudent doctor would not take that make the patient's condition worse. A few examples could be, for example, if someone comes in with a heart attack and they don't realize it's a heart attack and the person dies. Or one of the more common cases, which we've actually handled in our office successfully, is sepsis cases, where a person comes in with sepsis, which is a very significant inflammatory response caused by an infection. We know the protocol is to administer broad-spectrum antibiotics because they don't necessarily know what bacteria is causing the infection, so you have to give a wide variety of bacteria to address all possible infections because it's such a fast-moving bacteria and such an aggressive bacteria or condition that you don't necessarily have time to figure out what you're dealing with. And if you take the time to figure out what you're dealing with, the patient's going to die. So sepsis cases in particular are one of the cases where the failure to administer broad-spectrum antibiotics like right away can be considered a departure from accepted standards of care. Other examples include contraindicated drugs. So where a physician is prescribing one medication, they have to know and be aware of what other medications the patient is taking and look out and take appropriate steps where you have a drug-on-drug reaction, where one medication may do one thing, another medication they're on does something else, but where the two are combined or administered in unison, that creates a problem. One of the most common examples of this, or a few of the cases we've been involved in, involve autoimmune suppressants, which are medications which reduce the body's natural ability to handle or to address or fight an infection. And we introduce that in combination with other medications that can have an adverse effect. It can also have an adverse effect where, for example, you administer autoimmune suppressants in a patient that has a latent infection. So the doctor who's ordering or administering something like an autoimmune suppressant really has to do their due diligence in looking at a patient's history, looking at the blood work to see what the patient's underlying conditions are. And if they have some kind of latent infection and you reduce the ability of the immune system to keep that particular infection in check, you're not going to let the infection run wild. So those are some of the cases that we've been involved in, and that's a general definition of what medical malpractice is. The common arguments we deal with from the defense side, of course, is that what the doctor did was medically appropriate, or that the bad result is something that happened, but it wasn't their fault. That's why we always have to work with experts who can really explain and understand the medicine and explain that if the doctor didn't do this particular thing or took this particular step, the result would have been different. And that's really where a lot of the battle becomes in medical malpractice, is the doctor saying what was done was medically appropriate under the circumstances, and they always have reasons why it was done, or why something was done, or why something wasn't done. And we really have to be able to use our own medical experts to debunk those claims.
That's interesting because as a lawyer, you're not going to be the expert on this yourself. So developing these relationships and having these other experts that you can consult with is of vital importance. Tell us more about how you go about developing those relationships and how you use them in each of your cases.
Well, every medical malpractice case requires an expert. So typically we'll go through some third-party matching service to find an appropriate expert. But before I can even file a complaint in court, I have to certify that I've had an expert review the case and they've agreed that there's a reasonable basis to believe that malpractice occurred. So basically, we always have to get the patient's medical records and whatever tests there are and submit them to a completely independent doctor for review. And if the doctor says there's no case, generally we would decline the case. But we only go forward on cases where we've gotten opinion from a physician in the same specialty who says, yes, there was a departure from accepted standard of care. Here's what it is, and this is how it caused the injury or illness or the condition.
Right. It seems that the medical expert understands how, I won't say the game of medicine, but understands how medical practice is supposed to be. And they can confer with you and determine whether or not there's even a case to begin with.
Of course. We only use experts who have done the exact type of procedure or treated the exact same type of condition that our patient encountered. So you can only really use an expert who's knowledgeable and knows what the condition is, how the condition should have been treated, how the condition should have been diagnosed, and what would have happened if it was properly treated, and therefore can say that this doctor didn't do what he was supposed to do. And that led to a patient's progression of injury or illness or whatever.
Now, this again makes me curious about a typical timeline for how these cases are brought up and resolved, because I think, again, for most people, they're not very knowledgeable about how the justice system actually works. We're often surprised at how long and how slow work actually gets done compared to how we would prefer. So understanding what you just said, before you even file a complaint, you have to get the expert advice from somebody in the medical field who's dealt with that exact kind of thing. Maybe explain a bit more to set expectations for people who need to understand how long sometimes these things can take.
There's an inherent lag time or an inherent period of time which, in any case, especially in the beginning stages, the client's going to feel like, oh, nothing's happening. Why isn't the lawyer working? Why isn't he calling me? Well, the reason is, most time, because in any medical malpractice case, the first step is we have to get your medical records. We send out requests for the medical facilities, and then responding could take anywhere from 30, 60, 90 days. In cases of doctors who have committed malpractice and who are nervous, they try to avoid getting us the records. So we have to have our staff call them, harass them. Sometimes we even have to get court orders compelling them just to give us the records. And once we actually get the records, then we have to be able to summarize them, understand them, digest them, and get them to an appropriate expert to review and give us an opinion or feedback that there was a departure. Once we've gotten that step, then we have to file a summons and complaint, and we have to serve the defendants, and they usually get 20 to 30 days, depending on how they're served, just to file an answer. And then there's along with that answer comes discovery demands. Those discovery demands are often 50 pages of demands per defendant. So we've gotten good at taking steps to do it efficiently and to answer these. But once we even put together all the responses to those demands, and obviously those demands ask questions like, okay, what did the doctor do wrong? What injuries or illnesses were caused by the doctor's negligence or malpractice? So to answer those questions, we really have to know our case right up front. We have to have done the background and the investigation and taken all the preparatory steps to know exactly where malpractice was committed so we can itemize it, because if we don't itemize it, by the time we get to trial, we're not going to be able to pursue that theory. So there's so much investigation work that gets done up front. I don't think people ever really appreciate it or can really understand what the process is, and why it takes so long is because there's so much that has to get done up front. And then even when you do get the case filed, then it's not like you see on TV. You don't just show up. It's not like Law and Order. We just show up to court 10 minutes later and you have a verdict. There's a whole discovery process that has to go through for us to be able to properly build the case. We have to take depositions of the defendants. There's a whole discovery schedule that gets put in place. Often the defendants don't show up on the first time they're supposed to show up. And then once you get through that whole process, then you file something called a note of issue and tell the court you're ready. And depending what county you're in, that could be a 2 to 3 year wait from the time you're ready for trial. So that's why the timeline, and especially in medical malpractice cases, and particularly because they're more complicated, is as long as it is. Now, in terms of timelines, one of the things that people should be aware of is how much time do you have to actually file a lawsuit? What's the statute of limitations in medical malpractice? That's one of the more important questions. In part, that question depends on whether you were treated by a private individual or you were at a city hospital or a county hospital or treated by somebody who's employed by the city or county. So in a general standard medical malpractice case, the timeline in New York is 2.5 years, but we have what's called a continuous treatment doctrine, which means that 2.5 years doesn't start to run until the last date of treatment that you've had continuously for that particular condition. The rationale is you shouldn't have to commence a lawsuit against a doctor who's trying to sort of remedy the condition they caused by their own carelessness. So New York law does give you that extension. However, if you were treated at, for example, a New York Health and Hospitals Corporation hospital or one of the public hospitals like Westchester County Medical Center or one of the city hospitals like, for example, Kings County Hospital or one of those, then you have to file a notice of claim within 90 days. And if you don't file a notice of claim within 90 days of the incident which you're complaining about, you're going to be barred from suing unless you get a court order saying that you can file a late notice of claim. And then in the case of a municipal hospital, once you file the notice of claim, you only have a year and 90 days to actually bring the lawsuit.
I think that's a great way to help people understand and give themselves context on how long these things can take. And I appreciate you bringing up the statute of limitations and how a person needs to be aware of the timeliness of when they're filing and how they're doing it to stay on top of that. Michael, I know you also deal with issues of obstetrics and birth injuries. Would you tell us a bit more about what are some of the common cases you've dealt with in that area?
Sure. Some of the most common birth trauma cases involve something called shoulder dystocia. That basically means where the infant's being delivered vaginally or naturally, their shoulder gets caught underneath the pelvic bone. And what happens is the head starts to crown and the baby's just not coming out. So what happens is doctors who don't realize that the baby's in shoulder dystocia or in that position will start to pull on the head. And what that does is that actually rips the brachial plexus nerves, which is a patchwork of nerves. So you have a baby with loss of arm function in the arms. In general, once they realize that the baby's not coming out, they're supposed to realize or feel to see if the shoulder's entrapped or the shoulder's being caught up. And there's certain techniques and maneuvers they can use to free the shoulder without pulling on the head. That's one of the big areas of birth trauma that we've dealt with. Another area is where the baby's just too big to be born vaginally. And a lot of times what happens is the baby's head kind of makes contact or being pushed against something in the body because it can't be delivered. If you have a baby of a certain size, they're supposed to be scheduled for a cesarean. Another potential area is where a baby has a cord around its neck and they're supposed to be and it isn't getting enough oxygen. In that case, it becomes an emergency C-section or cesarean section that the physician needs to do. So if you have a baby that's born with brain damage, the first step obviously is to check the fetal heart monitor records to see if there's any abnormalities detected in the baby's heart rate, which may indicate that they weren't getting enough oxygen, and the physician should have picked up on the fact that this baby was either too big to be delivered or had a cord around its neck and wasn't getting the right amount of oxygen or was oxygen deprived, in which case it's an emergency. They have to do a C-section, and if they don't, obviously they're responsible for the resultant injury to the infant.
My wife and I just recently had a child, so hearing about these things are, of course, horrific. So my heart goes out to anybody who comes up against these trials and these hardships. But understanding these things, you had mentioned earlier that at some point in the case building process that the law firm would request medical records to start. But what responsibilities or what should people know about collecting evidence for their own case when it comes to medical malpractice? What should they be doing as soon as they can?
In the case of, for example, a newborn with birth trauma, they should be having the baby seen by an independent pediatric doctor to properly diagnose what injuries were actually caused, because you can't trust a doctor who may have just committed malpractice to give you a clear answer or the right answer as to what your baby's condition is. So I would say definitely have the baby or child evaluated by a independent doctor. The same thing as if you suspect that another doctor committed malpractice, seek an independent opinion. Let another doctor run the tests or send you for testing to determine what actually is your condition. Because that's the only way you're going to get a clear answer on whether it was malpractice, by knowing what your actual physical condition is.
And thinking back to, we had discussed getting the opinions of medical experts in other types of cases, you're talking about this here as well. When the medical expert says that there is likely a case of medical malpractice, to counter the initial argument from the other side that there is a reason for it, is it always the case that the opinion of the medical expert wins out, or does the counter arguments go back and forth even more?
Well, at the end of the day, it goes to a jury. So a jury has to listen to both sides and just decide who they believe and which version of the evidence they find credible and worthy of belief. That being said, once we realize what the other side's experts are saying, we do our own homework. We see what they've said in other cases. We look at medically, is what they're saying really feasible, and why isn't it feasible? So we really do dive into the medical records, and where they give opinions that there was no sign of a condition developing, we look for the notes that show that there really were signs and the expert isn't being 100% truthful or 100% candid, or maybe they just didn't do their homework. So there's always, there's a lot of strategy involved, especially in dealing with experts. And okay, one expert says one thing, one expert says the other. Well, we need to spend a lot of time figuring out how do we undercut the expert's opinion, or what are the facts in our case that show that this opinion, this expert didn't reach his opinion properly, because maybe a lot of times we'll see that he didn't consider certain factors. So it's not uncommon for a defense expert, for example, to give an opinion, but then there's a lot of things in the medical records or in the chart that they kind of ignore or look the other way to. So you can bring those up and say, well, doctor, did you consider this? Did you consider that? And it's like the old saying, junk in, junk out. So if you're ignoring information that's pertinent and critical, of course you're going to come to a bad conclusion. And that's kind of how we handle these cases.
And to begin to round things out in terms of the life cycle of a case, how often are these cases actually brought to trial where there's an actual jury versus it just being settled outside of court?
I'd say, well, settled outside of court is a bit of a misnomer, because most cases sit in court or in the court process or go through the process for years. And a lot of them settle during that timeline. So they're not technically at trial, but they are in court because papers have been filed, discovery proceedings are ongoing. I would say probably 90% of cases settle, but medical malpractice is unique, especially in New York, because most of the insurance policies require the doctor to consent to the settlement. And a lot of doctors will just refuse to admit that they did anything wrong. So some of these cases do get tried. That being said, we're able to settle probably over 90% of our medical malpractice cases because we're able to develop enough evidence, or we do such an effective job during the doctor's deposition that they know we know. They know that we can prove this case. So while they may delay consenting to a settlement until the last possible minute because they don't necessarily want it on a record because New York has a database, ultimately, in our experience, they do tend to consent to settlements.
I suppose it depends case by case, but I think generally people think of the law system working as, I'm going to take this all the way and get a jury to side with me and we're going to win the day. But in reality, like you're saying, often it may be in court but not at trial. That might actually be a more favorable outcome for a lot of your clients.
Well, a settlement always brings certainty. You never know how a jury is going to view conflicting information. If you have people whose family members are doctors, you don't want them on your jury. And unfortunately, you can't always get those people off of your jury. Being able to present a strong enough case so the defense knows they have a problem, there's a very real likelihood that they're going to lose, it goes a long way. And that comes from hard work, hard preparation, and being able to show them you can prove this case. Not every case ends up the way it should in a trial. There's the old saying, show me a lawyer that's never lost a case, I'll show you a lawyer that's never been to court. That being said, we've had very favorable outcomes because we work hard, and more often than not, when you do try a case, it goes the way it should go. But there's always risk. So a settlement always avoids that risk. And it avoids also the appellate process. Once you try the case and you've won and you have your verdict, you have your piece of paper saying you won, they file a notice of appeal. And in certain places, like the second department, that's now another 2-year wait just to get a decision.
And I think, again, you just mentioning that, it really helps to understand that things can take a while. So getting it to a reasonable resolution as quickly as you can is usually a good chunk of what it means to have a favorable outcome. Yeah,
there's a time value of money. There certainly is. There's also a benefit to putting whatever bad things happen behind you and moving forward with life. So that's part of the reason cases settle.
Well, Michael, thank you so much. I learned a lot, and I think our listeners did too. they got some great insight on how things work and what they can do if they ever experience malpractice such as this. This has been Trial Talk, Insights from legal expert Michael Joseph. I'm Sam Henninger. Remember to like, share, subscribe, because we will continue having great conversations just like this.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.